Hello, everybody out there in workers' comp world, land, internet land. Welcome to, I think this is manifestation 13 or 14 of our series on COVID and how it relates to workers' comp. So if you're listening to this, you probably have heard some of our webinars before. Some of our webinars with slides, and sometimes we have Zoom meetings, and this time we have a Zoom meeting. So as you can see, I am not alone. Let me introduce everybody here. So I'm Mike Sullivan. I'm a general managing partner of Michael Sullivan and Associates. It's I guess a medium-sized defense firm with 9 offices throughout California. And we do workers' comp, employment, immigration, civil, but mainly workers' comp and employment, really. I'm also the author of Sullivan on Comp, which is a comprehensive treatise covering all of workers' comp throughout California, with almost 7,000 subscribers. So we're really proud of it. And this session is a publication of Sullivan on Comp. So normally Sullivan on Comp does a bunch of webinars, and this is like that. But COVID is such a big deal that we decided we're going to share all of our webinars for free that we do. So it's a Sullivan on Comp presentation, but available to the whole world. And it's accredited. So if you're a claims adjuster, you get CE, and if you're a lawyer, you get MCLE. So that's what this is. This is installment number 13. We were talking about COVID a long time. There's a lot to talk about. We got through a lot of stuff. So we went through all the reforms in the employment law. We went through, the federal reforms, extra sick leave, FMLA. We went through when is COVID work-related and how does it relate to existing claims or aggravations of injuries. Went through psychiatric claims. We went through when do you provide a claim form? When do you provide TD? What's going on in litigation? And I interviewed Jake Jacobsmeyer, who actually had COVID and was in a coma for 2 months. What we're doing this time around is we're going through the facts, the frequently asked questions. So it's kind of like a review of the workers' comp law on COVID in general. And then what we did is after all of our webinars, people would write us questions. And we just still into questions that were most frequently asked. So we're going to give you a little rundown, sort of a summary of the different areas, and then we're going to go through the most frequently asked questions. And that's going to be our presentation today for an hour. Okay, so that's my introductory section, except I have to tell you who you're looking at. I told you about myself. So in order, according to my Zoom screen, we have Keith Figgins, lovely and talented Keith Figgins, who is a senior partner at the firm and oversees our Orange and Fullerton and offices. Yes, so he's responsible for a lot of things, and he's very tired, having recently adopted 3 children.
Yes. Hi, everyone. I am very tired. That's right.
Also very tired is Pilar Mitchell, who runs is a managing partner of our Fresno office. Say hi, Pilar.
Hello.
I was checking your volume.
Is it good?
Because she just made a human being last year.
I did. He's getting big.
Yeah, he is. Christian. Yeah. He's a cutie pie. And then finally, we have Anthony Culpepper. He's a supervising partner in our flagship office in El Segundo. Hello, Anthony.
Hi, everybody.
Anthony's just tired because he's working too hard and he's doing COVID. And I think you have kids too, right? You have like 3 kids or something, or 2.
I have 2 kids, yeah.
Yeah. And they're little, right?
Yeah, very little.
Yeah. Mine's 21.
Little but powerful.
They're little, but they have opinions. Yeah.
Yeah.
Well, mine's 21, so I'm taking it easy. I worry from a distance, but that's it. So anyway, so the thing is, the questions came out in like really just a few different areas, so we kind of consolidated them all. One was the AOE, COE, and psyche and death benefits. Another was, when do you provide a claim form? And then there was temporary disability, which Pilar is going to cover. And then there was the governor's order, which was such a big deal. We had to do an emergency webinar on that one. It was 2 in 1 week. So start with the governor's order. And Anthony, I was going to ask you to do a little rundown, like a 5-minute rundown of that topic, just so we have some context for the questions that we're asking.
Okay. Well, I'm sure everyone is fully aware of the governor issued an executive order on May 6, 2020. And I'm sure everyone out there has been listening to Mike's webinar, so that they know all this by heart. And this is just redundant for them. But I'm going to go over some of the main parts of the order just to set the stage for the conversation. So the order by Governor Newsom required a rebuttable presumption of compensability when 4 things were met. First, the employee tested positive for COVID within 14 days, that the employee performed labor or services at the employee's place of employment at the employer's direction. The second one was those labor or services performed were at the employer's direction on or after March 19th, 2020.
That was the date of the emergency order that shut down California, right?
That's correct.
Yeah.
That was a governor's stay-at-home order.
So it had to happen after that.
All right, next, that the place of employment was not the employee's home or residence. Okay, so it had to be at the employer's place of business. Lastly, the diagnosis must have been given by a physician who holds a physician and surgeon license issued by the California State Medical Board. And that diagnosis had to be confirmed by further testing within 30 days of that date of diagnosis.
Yeah, okay, I get it. So it wasn't for just essential workers, it was from anyone working away from home.
This is for everybody.
Yeah, anyone working away from home, but not at home.
Correct.
Yeah, yeah. And then there was the shelf life of this thing is from March 19th through July 5th.
That's correct.
Yeah. So you have to have been at work 14 days before you were diagnosed or diagnosed with the disease to show that you got it, or at least may have got it from work. Because there's a 14-day latency period, right?
Correct.
Yeah, okay, I get it. What else?
Also, again, it created a rebuttable presumption. So what that means is that, the presumption can be overcome with other evidence.
You forgot the air quotes at the other evidence.
Yeah, other evidence. And I guess we'll maybe talk about that a little bit.
Well, other than what, I wonder.
Yeah, right. Also, the compensability period or the decision date was cut down from 90 days to 30. So that was a big deal.
Yeah.
Yeah.
But
yeah, the governor did throw a little bone as well to employers and allowed apportionment to stay in place. So it can still be apportioned to pre-existing conditions.
Yeah, a lot of the bills out there would eliminate apportionment in COVID cases.
Yep. Also, with respect to TTD, and we may discuss this a little bit later, but those who were diagnosed subsequent to the governor's order had to be certified within 15 days of that diagnosis and had to be recertified every 15 days.
Yeah, that's so weird because it's like, normally in TD land, you can prove TD retroactively, but it's like if you don't certify within 15 days of diagnosis and then 15 days thereafter, you don't get TD. Isn't that weird?
Right.
And it seems to me to contradict the labor code in that sense. So I would guess that the courts would retroactively allow TD to be demonstrated despite this requirement, but I don't know. It's weird. It's really weird. I think it's because they're trying to say, okay, we're gonna be nice to the employers here and make them get certified so that,
Well, in these times, Mike, does the governor, have the ability to thwart the labor code?
I don't know. We talked about that when Jake was on, and Jake had a big theory about it. And that was one of the questions. Can the governor just legislate like this? And there's a lot of people that think he can't, but it may not matter because there's these 4 bills winding their way through the legislature, and one of them is out of committee, I think, and it's a rebuttable presumption, so it probably will replace this order, and it probably will be retroactive, I would guess. So I don't know, man. It's the Wild West. I imagine some of these the governor's orders will be challenged as exceeding his authority under the emergency statutes.
Yep. And specifically with respect to TTD, the governor's order requires, the employee to use any sick leave or, and I guess, a lot of employers are actually giving, specific types of leave just for COVID before they're entitled to TTD.
Okay. All right. Let me ask you some questions about this. Ready? So
I'm ready.
Questions from the world to you, Anthony Culpepper. So you only have 30 days to deny. The 30 days starts from when the applicant provides a claim form, right?
That's correct. Once the claim form is filed.
Yeah. A whole lot of people, like I interview lawyers all the time, and like half of them don't know this. They think that it's the employer's knowledge of injury, but it isn't. It's when the applicant provides a claim form. It's a Honeywell case. But how are you supposed to do that in 30 days? What do you tell your clients? I mean, how
well,
you do it in 30 days. I mean, you can't.
I mean, it's hard. I mean, I guess, the good part is it's a rebuttable presumption. So if you can't get what you need to get done to make a sound decision in 30 days, assuming you did your due diligence to try to get that information, you can always rebut it with other evidence after the 30-day period.
Yeah, what I tell the clients is I say, look, you can interview witnesses in 30 days, right? So if you're going to rebut the presumption, you're going to have to show they got it from somewhere else. So first of all the people at work, interview them, see if anybody's got COVID, right? And then take their statement and talk to their family members and see if there's any COVID there. That's probably enough for denial. You're not going to get a QME. You can get a COVID test by the treating doctor. You ask the treating doctor to get a COVID test. I mean, you can get them these days, right? They're becoming more available.
Mhm.
Especially if you're in LA County.
Mm-hmm.
I also tell them get on social media as soon as possible before they hide their social media accounts. Get them if they are at some sort of bar without a mask on, or they're at some sort of event and they're not taking precautions. Get that all documented right away before they realize they should hide it.
Details, I guess, huh?
True.
Yeah. How about this? How does this presumption apply to deaths resulting from COVID?
Well, obviously, there's a presumption that the employee has COVID, and if they have COVID and we're not able to overcome that presumption, then I think death benefits will be the same as with any injury. You have to show that there was a contributing cause to the death, that the injury, the underlying industrial injury, was a contributing cause to the death, and I think they're entitled to death benefits like any other claim. I guess the only difference is that the executive order wipes out payment to the is it death dependence?
Death without dependence unit.
Yeah, death without dependence unit.
State of California.
Right.
Yeah, if there's no dependence, then the state doesn't get its 250. Yeah. Okay.
I guess that's another bone for the employer.
Here's one. It says, regarding the executive order, does this also apply to staff who have alternating schedules? For example, works in the office Monday and Wednesday, but works at home on Tuesday. Would this be considered to have happened at work?
Can you say it again? I'm sorry, I didn't hear it. Can you say it again?
That's kind of an AOE question for Keith, I guess, huh? One of the questions that was asked was if they work like alternate days, they don't work some days. How does this executive order apply, or does it make any difference for the AOE analysis?
I don't think it makes a difference. I think if they are at any point directed to come into an office or come into the employer's place of business, and they meet all the other requirements of the executive order, I think the presumption still applies.
Yeah.
I would agree.
You would agree, because Keith is going to talk to us about AOE. That's what we're going to do next. Yeah. But Anthony, what about diagnosis physician's assistant? I mean, who has to do this? Because what it says is that the presumption applies if you either have a diagnosis or a positive test, right? And if you only have a diagnosis, then within 30 days of that, you've got to actually get the test.
Right.
Otherwise, your presumption doesn't apply.
Right.
And you're just back to regular old proving the case, which you can anyway. But
well, I mean,
who has to do the testing, or who has to certify?
so it has to be a professional license in the state of California as a physician and a surgeon. So I know what we see in our industry.
And a surgeon?
especially- Yes, and surgeon's license.
Oh, so they have to be both?
Correct.
Not either?
Not either.
Wow, that's not too many people.
Pretty tough.
Especially with the lack of availability of physicians.
Yeah, and what we see a lot of PTPs, you know, they're using physician's assistants to see their patients, and then they're signing off at the bottom. And I guess arguably, if the PTP holds a physician and surgeon's license and is signing off on what their physician's assistant is finding, maybe that counts.
Okay. I don't know. I mean, it's going to, remember though, it goes to the presumption, right? Whether or not you get the presumption, that's all it goes to. So we can use this to combat, because that's a threshold issue, right? Does the
Right.
presumption apply or not? And so that's, you have to have a separate finding of facts as to whether you meet the conditions for that before you get to the AOC reanalysis. So if you have the wrong doctor signing off on it, doesn't mean you win the case. It just means you might avoid the presumption if you're the defendant, right?
That's correct.
Yeah. One of the questions actually leads to my section, my assigned section of this group, which was, does a claim form need to be provided to employees who took time off work due to COVID symptoms between March 19th and May 6th, which is, you know, the date that the governor signed this presumption order. Does a claim form need to be provided? Now, you guys can ask me questions on this one, I guess, or I'll ask myself questions. Anyway, I mean, look, under what conditions does an employer, I mean, I've had so many, this was the big question for a long time, right? And for all my clients, it's like, okay, under what conditions do we have to, or should we provide a claim form to people with COVID?
Those are two questions though, Mike, right? Do we have to and should we?
Yes, they are two questions, and they're two separate questions.
They are.
Yeah. So, I mean, look, the legal answer was under Honeywell, you know, there's this case, Honeywell, which is a Supreme Court case which sets the standard. And in that case, the question is, when does an employer have knowledge? Because when an employer has knowledge that there's an industrial injury, they're supposed to provide a claim form. And then the applicant fills it out, gives it back, and the 90 days starts, or 30 days. So what constitutes employer knowledge is the question of when you have to provide the claim form, legally speaking. So the case in Honeywell, what happened was the woman calls and says, my husband is checking into the psychiatric hospital, and your head games have pushed him over the edge. Now, is that employer knowledge?
No.
Sounds like employer knowledge. It's not. According to the Supreme Court of California, it was not. And so it's a really high standard. They said reasonable certainty that the applicant has a work-related injury is not sufficient. So I told all my clients, I said, you don't legally have to provide this claim form under almost any scenario I can imagine, other than the applicant saying, I want a claim form, or I have a work-related injury. If the applicant says, I have COVID, no. That wouldn't be, to my mind, that would not be knowledge of work-related injury, right? So I think I have COVID, I might have got it from work. It's a little more sketchy, but I think under the standards of Honeywell, you still wouldn't have to provide a claim form. You just send them home sick. But you know what happened was that under OSHA came out in late May, and OSHA is the organization which keeps employers acting safely with regards to their workers, right? And they'll come in, they want reports on industrial injuries. There's Cal OSHA and there's federal OSHA, and they want you to report, and then so they can investigate you and see if you're not safe. And they said that if someone has COVID, you have to ask them where they got it from. Mm-hmm. So all this advice, I mean, I'm like, uh-oh. Employers, don't ask, don't tell. You know, that's what I've been telling. But now it's like, oh, you have to because of OSHA. So that was not so good. anyway, we wrote it all up in Sullivan and Comp. But the questions I got on this area, so I think that's a pretty important point. You know, I want everyone out there in the world to know that that knowledge is a really high standard. Now, there's a whole separate analysis of whether you want to actually provide claim forms anyway, just because that's the kind of employer you want to be, or PR purposes, or relationships with the union, or, you know, I had one client and they're like, look, the serious cases are going to get filed anyway, for sure. You know, it's not like we're going to avoid them. We're a union environment. People are going to know to file workers' comp claims if they die or they're on a ventilator. So we're just going to give claim forms to everybody, because what have we got to lose? And that way we don't look like jerks to our employees, and we're trying to be supportive of people in this era, right? So, you know, but other employers are like, nah, I'm not going to borrow trouble. I'm just going to give everyone a claim form that has COVID, because we're all going to file it, whether it's meritorious or not, and then we have to process it. I mean, you know, it's dumb. So, yeah. But one question was, will the injured worker need a positive test to file a claim? And the answer is no, you don't need a test to file a claim, but you are going to need a test to prove a claim, right? You can file a claim just because you feel like it. It's like, this is America, man. You can file a claim. Anybody for any reason at any time, or no reason at any time, right? I mean, filing a lawsuit, it's not Athens where you had a penalty of half that what you asked for if you lost your lawsuit. This
wow,
land of litigation.
Greek history. Wow, Mike.
Thanks, man.
Nice.
Yeah. Well, you know, I like to be a little intellectually superior.
Oh.
I just read enough to pull quotes out and occasionally throw them out. Anyway, another question was, let's say the injured employee has corona and is placed in a coma, or is in ICU, they're sick, so they can't get a claim form, and we're not supposed to make physical contact. Should we still deliver them a claim form? And the answer is no. You can't invade their ICU hospital room and give them a claim form. I want to mail it to them. But there's an important point here, and that is that a claim form doesn't have to be filed for an employer to be obligated to provide benefits if they otherwise know that there's a work-related injury. So if you knew that it was work-related, if you knew it, then even if you couldn't get the claim form to the person, you still have the obligation to provide medical benefits immediately. You know, there's this overriding duty to be proactive in workers' comp about providing benefits. It's a benefits administration system. If you're not proactive in investigating whether someone needs benefits, the audit unit will crawl all over your head, and rightly so, because you're supposed to be proactive, not just sit idly by and, you know, hope that no requests are made. So even if a claim form can't be provided, you know, if there's knowledge, then there needs to be provision of benefits. But again, standard for knowledge is pretty high. So that's all the questions I had for myself. Maybe we'll move on to the next part. Give us a little rundown on the AOE, COE stuff and for COVID and workers' comp. Just set the table for the questions we have.
You just want me to cover AOE, COE, and psych in about 5 minutes? Not a problem. I can do that. Yeah, not a problem.
I can do it. Let's see if you can.
So typically COVID-19 is not going to be considered a work-related injury. When we're looking at non-occupational diseases, they're typically not considered on workers' compensation claims. However, there are some exceptions. And employees have different avenues for attempting to establish that they did contract the coronavirus at work, including that the work subjected them to a higher risk of catching that virus. And so there are some exceptions. There are some exceptions, Mike.
That's an exception that swallows the rule, man. I mean, if everyone has to stay home, then everyone going to work, aren't they at a higher risk than the general public?
Well, so it depends on the current circumstance of where we are at, Mike. It depends. So okay. It's not very well defined. A lot of the case law that we're working off of is from over 100 years ago when the Spanish flu worked. So that's really the last time that the California Supreme Court really delved into pandemics and epidemics and how we deal with that in the workers' compensation system. So it's an ever developing and ever evolving way that we're looking at these issues. However, even if the employee cannot establish that the virus was not industrial related, they can argue that the virus was aggravated in an industrial condition. So that would leave the employer liable for death benefits, increased disability, and other forms. So employers can be liable for injuries related to COVID-19, including psychological claims, which I'm going to talk about in a little bit.
So you're saying that, like, if I have an underlying back injury and I get COVID or heart disease or lung disease, and that's an underlying workers' comp case, and I get COVID that's non-industrial, and I get aggravated then in my heart and my lungs, then that's compensable, that aggravation.
You're still treating that body part as that industrial body part.
And then vice versa, if I have industrial COVID, and then I have let's say I'm a smoker, which I was until 6 months ago.
Congrats. Thank God.
Yeah. That Chantix was awesome, man. I recommend it to all you smoking quitters, because it's just like you don't want to smoke anymore. It's amazing. But anyway, this isn't about me, okay?
It's always about you.
If you have,
It's about Mike interrupting Keith. That's what this is about right now.
that's what I do, Keith. Okay, so if you have like an underlying non-industrial thing, so you have heart, let's say you have emphysema, and then and it's non-industrial, and then you get COVID and COVID's industrial, and it aggravates the emphysema, then does the emphysema become industrial?
Well, if the emphysema was already industrial in nature, then yes. If it was if the industrial COVID aggravates the emphysema, then yes, that is industrial.
Well, but only the aggravation, right? Unless
Correct.
It's temporary, yeah. Unless it's like, and then you go back to where you were before, then.
So it's a difference between an exacerbation, which is temporary, and an aggravation, which is permanent. So any exacerbations you just treat until they go back to baseline. Any aggravations is something that makes it permanently worse, and then you do by that and you treat that. So it is important that we realize, though, that the law distinguishes between occupational diseases and non-occupational diseases. The labor code doesn't really define occupational disease, but they do define occupational illness, which is an abnormal condition or disorder that is caused or exposed to environmental factors that are associated with the employment. So this can include any type of acute or chronic illnesses. It could just include diseases caused by ingestion of something, inhalation of something, absorption of something, any direct contact of something. So then we look at what actually happened when the Supreme Court back in, I'm not actually sure when they made this rule, but when they were interpreting a non-occupational disease, when it can be considered industrial in nature. So one is that it's not contracted solely because of an exposure at work or because it's related to a particular type of work. They gave 2 exceptions to the non-compensability rule for any non-occupational diseases. And those were that if the employment subjects the employee to an increased risk compared to that of the general public. And then the other one is if the immediate cause of the injury is an intervening human agency or instrumentality of that employment. So what we're looking at to see is, does the employment place the person who is at work at a greater risk than the general public would be at? So otherwise, it's not considered a compensable claim. These viruses would not be considered compensable. However, if you are being at work and you are placed at a greater risk than that of the general public, then it would be considered compensable. And so that's what the applicant has to prove. The way that this has been interpreted, at least 100 years ago it was interpreted, is there was a case that the Supreme Court looked at where there was I believe he worked as a steward in a hospital. And the Supreme Court looked to see what the infection rate was with the employees of the hospital versus the general public. In the hospital, I think it was like 85% infection rate for people getting the Spanish flu, whereas the general public had a 10% infection rate. So they looked at that and said, based on the employment, they have a much greater risk of getting infected with the Spanish flu in their work site. And so they did find that to be compensable. So that was a bright line rule that they were kind of making for us to help determine.
Sounds a lot like what we got going on now.
It does.
Yeah.
So that's generally AOECUE with COVID-19. But when we look at psych, it's a whole different level of AOECUE, how we're looking at actual events of employment. So typically, in order to establish a psychiatric claim as compensable, the injured worker has to prove by a preponderance of the evidence that there's actual events of employment that were predominant to all of their causes. As we all know, predominant cause is 50% of the overall condition. But the phrase actual events of employment is not so well defined in the actual labor code. So it's been interpreted in several ways by the courts. It has been found that any subjective misperceptions of employment being stressful cannot support an award of actual events of employment. But what the Court of Appeals has said is actual events of employment is there must be an event. So that's something that takes place. I love lawyers. We have to define event. That's something that takes place in the employment relationship. And second, the event must be of employment. That is, it must be something involving the working relationship between the employer and the employee. So it's found that broad societal events like, downturn in the economy, which none of us are experiencing right now, could be an actual event of employment because we're all experiencing it. It's not something that just that person in that job is experiencing. But changes in the workplace in response to the COVID virus that might affect an employee might qualify. So some of these examples would be like a change in a job assignment, changes in work duties or work conditions, stress related to a new computer system, like going to have to work from home. Those are things that could be considered an actual event of employment.
Those would be actual events of employment if you did that. Those things happen.
Yeah, so a lot of employers are fundamentally changing the entire way that we work in this system. We had to send people home because of the government's order. So a lot of employers are saying, well, the government told me to do this, so how can I now be liable for an actual event of employment that causes stress? The way the system has dealt with it is too bad. You had to do it. It doesn't matter if it's government mandated. If it's an actual event of employment, then it can lead to a compensable workers' compensation.
So what you're saying is that fundamentally, the applicants that are people that are sent home to work, if they have a psychological injury, and that means even if they don't have COVID, like if they're just upset because they have to work at home with their spouse, stand their spouse,
that's right?
They have a psychological injury.
Now, how complicated is that?
I'm talking about. Paul knows what I'm talking about. I mean, that would be actual events of employment. That could be work related if I'm stressed because now I have to work at home.
Yeah, so I mean, it depends what the person's complaining about. If they're complaining about, I hate my husband and my husband drives me insane, that, maybe not. But if they're saying I have to work from home and that's causing me stress because now I'm in a stressful work environment at home, then yes. So it really depends on the factual nature of each individual case. But what's important is that those are actual events of employment because the employer sent that person to work from home. So that just opens the door wide open. Now, I haven't seen any of these really come across my desk so far. I don't know if Pilar or Anthony has seen any of these come across their desk. But it's a door that's wide open for the bar to raise. Now, once we do have actual events of employment, there are some defenses that the employers can raise.
Wait a minute, though, before you go there, I want to confirm with you. What if I'm worried that the company's going to go out of business, I'm going to lose my job?
Well, so overall, you can't, big societal things cannot be actual events of employment. So no, you can't, that's not.
What if I'm worried that my 401k is going to go down because the stock market's reflect, is that, I mean,
so that goes back to the definition. That goes back to the definition of what an actual event of employment is. It has to be an event. It has to be an event, and it has to be related within the employment relationship between the employer and the employee.
Yeah, that term actual event of employment is so weird because it's like, I ask this when I do interviews of lawyers, I ask them, what does that mean? Because it's a really esoteric point and almost like 90% of them don't know. But it's because like it obviously was intended to circumscribe the range of cases that would be compensable. So it's a smaller zone than the idea of something being work related, right? And so what does it mean to say it's actually an event of employment? That this is the first time with COVID that this issue is really coming to the forefront, like that people actually have to deal with this. And I think everyone's going to learn what it means. Anyway, I'm sorry.
It's all right.
Philosophy of workers' comp law.
So once it is established that there's an actual event of employment, there are some defenses that can be raised. And these are important to raise just in the terms of what we're talking about later on, some of these questions. So a good faith personnel action defense when we're looking at an actual event of employment versus a personnel action. So not all actual events of employment are personnel actions, but all personnel actions are going to be considered actual events of employment. So the courts have explained that what constitutes a personnel action depends on the subject matter and the facts of each case. I know that's not really very helpful, but it's got to look at the individual facts. You got to look at how it applies to that individual person. So personnel actions may include transfers, demotions, layoffs, promotions, performance evaluations, things of that nature. In contrast, it's been held that the changes in working conditions do not constitute personnel actions. So changes in working conditions such as working at home, a change in a workload, those are not personnel actions. So those are actual events of employment, but they're not personnel actions. So
those stay-at-home workers, the door stays open, even not only for the standard of proof, but also for the 3208.3 defenses. Good faith personnel.
That's right.
You're vulnerable as an employer to these claims.
You are, because it's an actual event of employment, but not a personnel action. So in that analysis, when you're looking at a good faith personnel defense, you're not meeting that initial threshold. Although it's an actual event of employment, it's not a personnel action. And that has been defined that way by the courts.
Of course, it's a highly fact-dependent analysis, like you're saying. I mean, there's a lot of stuff that is personnel, that are personnel.
Did I not say? I should have said generally. Generally, that's my defense, my attorney response.
The devil's in the
generally.
Well, it's going to be on, isn't it? It's going to be on, like at the board between the defense attorneys.
It is. So
I trying to discover in 30 days.
I think it's a fairly decent summary of AOEC with cite.
You did a good job, Keith. I'm very proud of you.
I do 5 minutes. I don't know. I just found out my clock in the background is broken, so I don't really know what time it is.
We're doing okay. Let me ask you some questions now from the workers' comp community.
Sure.
Are you ready to stand before the community?
I am ready. Bring it.
Okay. So let's say healthcare professionals, they utilize full protective gear, like nurses or doctors, per Cal OSHA guidelines. How would they have a greater risk than the general public during a widespread outbreak? I mean, the fact that they're wearing protective gear should protect the employer from a claim, right?
So, Mike, it depends. Whether personal protective gear is sufficient is going to really be a determination that's made at the appeals board based on the individual facts of the case. So certainly the fact that you're giving employees personal protective gear is something that is important and something that should be raised as a defense. However, it's not going to be a all-encompassing defense to say that they couldn't have gotten COVID-19 because they were provided personal protective gear. So it depends on the specific facts of the case, but it is possible that it can be raised as a defense. It also is possible that it's not going to work as a complete defense. Employers have to provide the personal protective gear to the workers, providing care to suspected and confirmed COVID-19 cases. That includes gloves, coveralls, masks. I know there's a shortage. I think we've gotten that shortage more or less ironed out. But the employees that are actually treating the people with COVID-19 absolutely must be wearing protective gear. If you're an employer out there and you're in that field and you're not doing it, you absolutely should be doing it. So,
well, how about this question? Let's say that the employee refuses to wear his or her gear, or the equivalent sort of behaviors where they're disregarding their own safety, disregarding the regulations about what they should be doing, and they catch COVID.
Mm-hmm.
Number one, is that work related? Still, they did it to themselves.
Mm-hmm.
And then number two, if it is work related, would that be a serious and willful violation on the part of the employee? You know, you can do serious and willful against employees as well as employers for reckless behavior.
Well, so the first part of that question is it's a no-fault system, so it doesn't matter, and it will likely be considered compensable, even if it was their fault. So benefits will be paid regardless of negligence.
What about the prohibition on claims if they're intentionally self-inflicted?
Well, so you'd have to prove that it was intentionally self-inflicted, Mike. It can't just be negligence. It has to be gross. You have to show intentional, that they're doing this in order to get COVID-19.
Okay.
If you have evidence showing that they're intentionally trying to get COVID-19, by all means use it. But I don't know what that evidence really looked like outside of somebody admitting, I really want to get COVID-19, so I'm not going to wear this mask. So again, that goes back to it's a no-fault system, and it's a no-fault system on the part of the employee and the employer.
So what about the serious and willful?
So the standard for serious willful is very high. It's greater than negligence. It's greater than even gross negligence is going to be. So again, you have to prove that they're intentionally doing something with the knowledge that it's going to result in some sort of serious injury. And they just show like a wanton and reckless disregard for the possible consequences of what that would be. Somebody who's not wearing a mask properly, like they don't cover up their nose. I don't think that would reach the the threshold of wanton and reckless disregard for possible consequences.
Works both ways, right? Because like as we're setting up our workplaces for people to come back to work, there's all kinds of guidance and from all kinds of organizations, federal and state.
It's certainly not something that I would rule out completely. You should explore it. If you have somebody who's just walking in and saying, I don't care about any of you people, I'm not going to use hand sanitizer because it dries out my hands. I'm not going to wear a mask because I don't like them. I'm not going to wear gloves.
No. What I mean is the employer could be liable for a serious and willful if they did not put into place sufficient safety protocols
certainly
upon return to work.
Certainly, I would think so.
Really?
I would think so, yeah.
Behavior? Is that beyond gross negligence?
They could potentially. It
so
depends,
the employer
Mike.
can get nailed, but not the employee, huh?
Well, it's almost like the system is built that way, Mike.
We did this in our firm. We talked about, we didn't know if we wanted to do temperature checks. We're doing everything else. But temperature checks are recommended in only certain circumstances as a question of prudence. And so we thought, if we don't do temperature checks, might that subject us to an SW?
Well, I think you'd be more likely to be subject to a serious and willful as an employer if you are aware that somebody has COVID-19 in the office and you do absolutely nothing to protect the employees from it. That would be a much more likely scenario of having a serious and willful claim. I don't think not taking temperatures would meet that burden. I don't think that maybe not having enough hand sanitizer would meet that burden, but actually knowing that there's a danger and not doing anything to protect your employees, that would be a serious and willful claim.
How about this question? If the employee refuses medical care or refuses to file a claim, what are you having the employee sign a waiver?
Well, I guess it depends what you mean by waiver, Mike. You can't waive workers' compensation benefits in the state. But what I do recommend is that when you're aware of an injury taking place and that employee says, I don't want any medical treatment, you can have them sign a declination of medical treatment. And I highly recommend you do that. It's not going to prevent you from later on being liable for a workers' compensation claim. But what it does do is it shows that you offered that treatment and they declined it. So you're really showing that there was no denial of care in the very beginning. So you're walking out without clean hands.
I was called by a client recently and they said, what happened was the person got COVID and went into the ICU. And the employer reported it to us, the carrier or the TPA, and said, okay, here we go. Put this in as an incident, because they report incidents even if they're not actually claims. What do we do now? And my answer at the time was nothing. I mean, you don't have a claim. All you do is that somebody who works for you has COVID.
Yeah.
Signing a waiver doesn't work in workers' comp. You can't waive workers' comp. It doesn't work that way. But under the OSHA guidelines, and I'm lapsing back into my section here a little, but they're connected. I think you'd have to make inquiry. If the employee's not available from maybe, some of the possible witnesses to see, if COVID actually could have been linked to work. Now, even if you knew for purposes of OSHA, it's a sort of a preponderance of evidence standard, which is not the same thing as knowing beyond reasonable certainty, right? So you could report to OSHA and still not provide a claim form. But these kinds of situations are probably a very good idea to run by your lawyer.
Mm-hmm.
Yeah. Let's see. What else did they ask? A lot of these questions are centered around different fact scenarios. Would this meet the burden of proof? One is let's say there's a small meeting, 8 people, and 3 of the 8 contracted COVID. What would be your analysis of compensability?
So I mean, first it would be it depends. Second, it would be assuming the presumption this falls outside of the presumption. We'd have to look to see just whether or not how widespread the disease was at the point. So what point in time did this happen? Was it widespread enough in the general public where they could have gotten it somewhere else? Were we opening? Were we closed? Were we semi-reopened? Is there an investigation that's done? Are we doing any contract tracing of the family of the person who got COVID-19? Are we looking to see where that person was? Were they out in the general public already, not wearing a mask, not doing any type of protective or a social distancing that they should have been doing? So it really depends. I can't give you an answer like, yes, that's absolutely a compensable claim, or that's absolutely not a compensable claim, because it really depends on the individual facts of that case. Were they being placed at a greater risk than the general public? And if they were at a greater risk because they were in that group of 8 people and 3 of those 8 people got COVID-19, that could be a coincidence. It also could be that they all got it from each other. So it would just be a really fact-based analysis, and that investigation has to be done really early on. And I can't concentrate on this enough, that the contact tracing is so important to see. I think Mike mentioned this earlier, is that not only are you talking to the worker, but you're talking to that worker's family, you're talking to their roommates, you're talking to the people they live with, you're talking to people that they're in contact with. If you've ever seen Outbreak, or if you've ever seen any of the movies that deal with these pandemics, the one thing you should take away from those movies is go talk to the people that person's talked to. That's the only way you're going to find out where they've been and what they've been exposed to. And so it's important to do it early on.
And for our listening audience, our next presentation is going to be an interview with a doctor about COVID. And then the one after that's going to be on the federal and state funding, the PPP, the emergency funding, stuff like that, with our accountants. But the one after that's going to be on contract case tracing. So we'll have a whole webinar just on contact tracing. So, okay, let's move on to Pilar. Pilar, who has been uncharacteristically silent so far.
Save the best for last.
Very disconcerting not to hear you talking.
I didn't want to interrupt Keith or Anthony.
Well, she's like, with me and Keith talking, she can't get a word in edgewise.
That's true. Keith is a fast talker.
He is. And he's nimble of tongue.
He is nimble.
Yes, he is. He's a smooth talker. Anyway, so tell us about temporary disability. This is another area where there are a lot of questions are being asked. What's the issue there?
Sure. So temporary disability, I guess we're kind of getting into the good stuff. We're talking about money now. We're definitely getting quite a few questions about indemnity, when it's payable, when it's not. And it does seem like a lot of clients are getting lost in this idea of COVID-19 and the pandemic, and losing sight of the fact that the very threshold issue to be entitled to any benefits under the work comp system at all, we have to be dealing with a person that has an actual workplace injury. If the threshold issue does not involve an accepted workplace injury, then you don't even get to the issue of benefits at all. So as a general matter.
So like someone on quarantine,
right?
Do they get TTD?
No.
You're right, yeah. That's one of the questions. I jumped the gun, I'm sorry.
No, and that's okay, but I think that's a really important point. I mean, when you're questioning some of these things, one of the most crucial questions you can ask yourself is, are we even dealing with a workplace injury to begin with? Or an injury or a condition that arises out of employment. Just as a refresher, temporary disability benefits are paid as wage loss. So there has to be some industrial injury that actually results in lost time from work. And that lost time from work has to be the direct result of the industrial injury. So it cannot be for some ancillary reason. So like Mike was saying earlier, one issue that has come up quite frequently is this idea that employees are needing to quarantine because of a potential exposure they had outside of work to the virus. They don't have the virus themselves, but and there's no allegation that they were even exposed at work. It's just, they have to quarantine because they were around a family member that had it. That doesn't entitle them to any work comp benefits, let alone temporary disability. They may be entitled to other leave like FMLA, But here we're going to just talk about temporary disability. So
I think the emergency sick leave that the federal government's providing or mandating does cover quarantines, if I'm not mistaken, if I remember correctly.
it does.
Yeah.
From
Yeah.
what I read. I'm not an
That's
expert
really
in that area,
something,
but it does.
yeah. You know, there's a case on that. I remember it was a nurse with someone with pneumonia, and then they sent her home for 14 days to make sure she didn't have it. She said, give me temporary disability. And the court said, no, you don't have a work-related injury, so you can't get benefits.
Right.
Because she was never diagnosed with the condition. She never had
What about, Pilar, what about the cases that we're seeing? Somebody has, you see this question a lot. Someone has temporary partial disability, meaning they have work restrictions, which the employer is accommodating,
Okay.
right? So, you know, you got injured, you hurt your back, and they have you in an office job sorting paper clips. But then they send everybody home,
Mhm.
right? And now you can't work because you've been sent home. And normally, if the employer doesn't offer you a job when you're temporarily partially disabled, you're considered temporary totally disabled. So in that case, but the other argument is, well, they're not. But the reason that they're not being offered a job is because of COVID, not because the employer wouldn't otherwise have a job available for them. So how does that shake
Right.
out?
I mean, it kind of exactly what you said. So I know there's kind of two schools of thought on this, but if you're working modified duties and the reason that you're off work is completely unrelated to your actual injury, for example, your entire department is furloughed, then you wouldn't be entitled to workers' comp benefits for that because your loss of time from work is not the direct result of your actual injury.
Yeah, I think that's the conclusion we came to. We did the whole webinar on it, and it's a pretty involved argument, isn't it?
It is, and it goes also to the point of if you do pay temporary disability to benefits to the injured worker, but you're not paying benefits to everybody else that was furloughed, then are you discriminating against those people? Some sort of reverse discrimination. I mean, I don't want to go too much into that, but really to be entitled to the indemnity or to temporary disability benefits, your loss of time from work has to be directly related to the injury itself and your employer's inability to accommodate because of the injury.
Okay, you ready to face the nation? You ready to face California workers' comp community's questions?
I think so.
No, yes, you are. Yes.
I'm ready. Woo!
You have to project confidence, Pilar.
Confident. Let's go.
All right. One of them is, wouldn't it be better for the employees just to file for unemployment and take advantage of the extra $600 a week?
I mean, it doesn't change the analysis in terms of whether or not they're entitled to temporary disability. What you're talking about is someone potentially gaming the system and figuring out a way to get more money from one from one department versus another, but it doesn't change the analysis as to whether or not temporary disability would be due.
So you might say to your employer, please lay me off or fire me. Don't just send me home, right? You know, my daughter was working a minimum wage job as a waitress while in college, and she got a little bit of money, and her unemployment was very, very little, right? But the federal government's giving $600 extra per week, no matter what your unemployment is.
Yeah.
So a lot of people are better off being unemployed, which is interesting. Employers probably shouldn't, but maybe do take into consideration that their employees would be better off if they were laid off.
Yeah, I mean, I saw a similar case where someone had applied for the small business loan to bring back their employees, and their employees got upset because they were making more money off of unemployment. Like, don't bring me back to work.
Okay, so here's a question. We have a claimant who's TTD until seen by a specialist. The transfer of care to a specialist is taking extra long time because they're not available because of COVID. Now they want the TTD to go until they see the specialist. How does that work? What do you do there?
Okay, so in that situation, you're talking about someone who has an industrial injury prior to COVID, and they're already treating. It is possible to prolong temporary disability pending either a diagnostic test or an evaluation by a specialist. But we also have to remember that the requirement to issue periodic reporting regarding temporary disability is the duty of the primary treating physician, not the secondary treating physicians. And the primary treating physicians for non-COVID related cases have to issue periodic reports every 45 days. So I would say that if someone cannot get into a specialist, their TD could be delayed, or their TD would be able to be continued, because it would be unreasonable to deny it based on the fact that the specialist can't see them because of COVID. However, if there's another mechanism by which you can try to get an updated report, for example, sending them back to the primary treating physician, I would explore that, because you always have the potential that the PTP could offer modified work duties that allow you to reduce your exposure on TTD.
Okay, that's a good answer. Here's another one. If you opt not to pay TTD or wage loss due to COVID layoffs or reduced hours, should you still send the TD delay or denial letter?
Yes, always.
Yeah,
I think that's an audit
right.
issue, basically. You have to send the notices.
Okay, what if before the employee got COVID, they were already temporarily totally disabled for something else? Would that continue?
And they're still TTD? Yeah.
Yeah.
Okay.
Yeah.
Yes.
Yeah.
Glenn.
Yeah.
You're like, wait a minute, that's too easy. Something's wrong. You're tricking me. Let's see. If an employee is being, well, I think we already answered that one, sorry. One question is, are substitutes, and I think they
Did
meant
have a dense
substitute teachers here,
Mhm.
in the TTD if the employer is accommodating restrictions?
I mean, there's no, if they're an employee that's, their restrictions are being accommodated, then they're not entitled to TTD. Maybe
Yeah.
wage loss if there's some sort of differential between what they were making prior, but not
Right.
TTD.
Okay, it's a big deal for a lot of school districts.
Yeah.
Yeah. And
With
then,
the schools all closed though, and there's no substitute teacher positions available, are those people supposed to get temporary disability benefits if there's no jobs available to them?
well, it's the same analysis as like, well, if they're temporary
Mass furlough.
analysis, right?
Mhm. I think it goes back to whether or not everybody's laid off or whether it's just the people on modified duty.
Yeah, well, the people at modified duty is the one that's the issue. You know, it'd be really an interesting issue would be seasonal employees,
Mhm.
but nobody asked that, so we're not going to address it.
Ask me. Let's talk about it.
Can't, we only got 3 minutes left.
Uh-oh. Okay, let's do this.
I was talking too much in the middle. Actually, it's Keith's fault. He was.
Keith was so long. I barely have any
I know.
time to talk. I
Yak,
should've gone
yak,
first.
yak, yak, yak.
You guys
I
gave me
know.
AOE Sealy and Sight. Come on.
Here's one last one.
All
If
right.
there's an employee working modified duty and they're over 65 and they're being encouraged to stay at home and self-isolate, then they get TTD?
No.
You
So
already-
you're,
No.
yeah,
And I might
I
add
mean, your
that you
entitlement
can't
to the,
discriminate against
exactly. I
people.
mean, being over 65 isn't a disability, and it's not,
Right.
definitely not a work-related
All right.
disability.
See you guys
And you
later.
can't tell people over 65 or even people with comorbidities that make them more vulnerable that they can't come to work.
Mhm.
We covered that in the employment law stuff because it's discriminatory,
Yep.
right? Okay. Well, folks, I'm afraid we're down to our last couple of minutes, and time flies when you're talking about California workers' comp. The good news is we can get off this and just talk to each other about workers' comp, so the joy doesn't have to stop, but that's for our listening audience. So just to remind you, next week we do have a doctor coming in. We're going to COVID-19 in depth, and we are going to cover a lot of related topics in the future. We're every Thursday at noon for an hour, sometimes an hour and a half, if you're lucky. So thanks for listening in. And as always, if anybody listening has any comments or questions at all, please send them. As you can see, they're useful to us. We consider them, we answer them. If you want to say something nice, that's okay. If you want to say something mean, that's okay. Kind of. Well, it's only kind of mean. But I want to thank Keith and Pilar and Anthony. You guys are great, as always. I'm really proud to have you as partners, and I appreciate your
Aw.
effort.
Oh.
With that, we'll sign off. Say goodbye.
Cheers.
Thank you.